Morning, everyone. Thank you all for joining our webinar today. So we are very pleased to share the next hour to discuss the impact that the new European Union Product Liability Directive will have on AI systems as well as products incorporating such systems. As you're all aware, liability rules have evolved in response to technological progress, and this webinar aims to shed light on these developments. So maybe just a few points before we begin. First, the webinar is being recorded, so you will be able to watch the replay of this session later if needed. And of course, if you have any question along the way, please use the Q&A button, and we'll take a moment at the end of this session to go through your question. In any case, we have questions to guide the final part of the discussions. Maybe before we dive into the discussion, I will now hand it over to our speakers to introduce themselves. So, Christelle, it's over to you.
Thank you very much, Hortense. My name is Christelle Koslan, and I'm a partner in Hogan Lovells Paris litigation team. All my career long, I've been dealing with questions around product liability, product safety, and with respect to a very wide range of products and services. And together, speaking alongside my dear colleague, Sebastian Pauli. So Sebastian, do you want to say a couple of words about yourself?
Thank you very much, Christelle. Thanks, team, and hi all. So I see a lot of familiar faces amongst the attendees, so thanks for joining. I see a lot of new faces too. For those who don't know me yet, my name is Sebastian Polly. I'm a partner and lawyer at our Hogan Lovells office in Munich. We have a team that's called Global Products Law, and like Christelle, my team and I, we're focusing on product liability and product safety topics. At heart, I'm a litigator, so day in, day out, we litigate and defend product liability cases for our clients, and we're very excited to be able to shed a little bit of light on the EU's new Product Liability Directive. And having said that, back to you, Christelle.
Thank you. And many of you may already be familiar with our products law team at Hogan Lovells. Together with many of my esteemed colleagues, we are part of a very strong and active network in all major European jurisdictions and in the US. And indeed, what we have been following very closely recently is a revision of the Product Liability Directive. As you may remember, the Product Liability Directive, which is called by the surname of PLD, was a landmark regulation established in 1985, and which after nearly a decade of discussions was finally updated a couple of years ago. The new PLD was really presented as marking a major shift. It's designed for a world where products are no longer just physical. Products nowadays are smart, connected, and also powered by AI. It's our topic today. And I would add also that one major difference we've seen over the last decade is the line between products and services is now very often blurred. And so the idea is quite simple. If technology evolves, liability rules must evolve too. And because there are a lot of things that the old PLD did not necessarily effectively deal with, there have been a long debate regarding how to revise it. Just to give you a feeling of what questions were discussed during this debate was whether the meaning of products extends to software and apps and the way products communicate, or does it only apply to tangible products? Who should be held liable for a product, for instance, in case there's a cyber attack and the cyber attack caused an accident? Is a manufacturer at fault for failing to make the product sufficiently sure against a cyber attack? Or most importantly, for all lawyers around the room, what level of safety is a person entitled to expect? Does it shift as further updates of a product are provided, e.g. When there are software patches? Does the level of safety to be expected differ depending on the complexity and purpose of the product? So these are some of the issues that the new PLD addresses. And so the first point on which there was a lot of debate was how to define the term product. So if we look at that, and you have the definitions from both the old and new PLD on screen at the moment, under the old PLD, a product basically meant any movable item. So something pretty straightforward and very focused on the physical world. Now, Article 4 of the new PLD provides that this directive applies notably to digital manufacturing files. Here you can think of instructions for 3D printers, for example, and very importantly to software. Note that AI systems are considered software in this space, and thus they fall under the definition of products. And this is explicitly mentioned in recital 13 of the new PLD. But it goes also further than that. The new PLD also covers product-related digital services that are essential for a product to function. These are services that are so interconnected with a product that the product could not be safely operated without it. So just to give you a couple of examples, a navigation system that relies on live traffic and road condition data, or a wearable health device that would depend on continuous cloud-based monitoring. And to keep innovation going, the new PLD leaves out from the products it covers both free or open source software developed outside the course of commercial activity and software source code. So these are not covered by the new PLD. In turn, provided specific requirements are met, an injured person is able to claim compensation for death, personal injury, or property damage, and even data loss caused by a defective AI system or AI product. So what does that mean concretely for companies and manufacturers? Well, greater risk of liability because the definition of product is much broader, and also a clear need for stronger protection. For example, it may be wise to review your insurance coverage to make sure all these new digital risks are actually covered. Now, another term that has been revised is defectiveness. Yeah, thank you, Hortense. So the new PLD maintains the traditional description of what is a defect in the product. So a product is deemed defective if it doesn't provide the safety people are entitled to expect, or when the product fails to meet the legal safety requirements. This involves an objective analysis of the safety that the public at large is entitled to expect, and not to the safety that any particular person is entitled to expect. In our experience, this is where it becomes very often tricky, because in litigation, there is a clear trend from plaintiffs to rely on their own circumstances to assess the defect. Thus, one needs to remind that specific point, because otherwise the notion of defect could become limitless and unpredictable. It is also worth noting that just like under the old directive, Article 7.3 of the new PLD clarifies that a product is not considered defective solely because there is a better product on the market. So it means updating your product, upgrading it, doesn't make the previous version of the product defective per se. If you improve your product, so you don't incur liability for the previous versions just because of that improvement. If we move to the next slide. So, however, the new PLD goes further than before and provides a much more detailed list of circumstances that products must meet to be considered free from defects. And you have the full list on this slide. So a few key points to note. The PLD refers to the presentation of the product, including its labeling, design, technical features, packaging, etc. So that's point A. This is broadly in line with the concept of presentation we had already in the old PLD. But that said, the new PLD clarifies that warnings alone are insufficient to avoid liability. So what that means is that while warnings and instructions are still very relevant, they cannot solely be relied upon to mitigate a product's defectiveness. This places a greater onus on manufacturers to ensure inherent product safety. And this is particularly relevant when one thinks of AI systems. The PLD also refers to the ability of a product to learn or acquire new features. So clearly that is a novelty here. So this criterion specifically addresses AI-powered products because as we all know, they evolve over time and can create unforeseen risks. So the new PLD explicitly provides that manufacturer that designs a product with the ability to develop unexpected behavior should remain liable for the behavior that causes harm. With respect to the criterion related to reasonable foreseeable effects from other products, including via interconnection, basically what that means is think about how your product might interact with others, especially in IT and software, where things constantly talk to each other. You don't have to predict every wild scenario, but what's reasonably foreseeable. So it's about anticipating realistic interactions, but not every possible scenario. And finally, if we move to the next slide, under the new PLD, non-compliance with mandatory cybersecurity requirements can form the basis for finding a product defective. Therefore, the new PLD makes it explicit that safety now includes protecting the product from third-party interference, not just preventing harm caused by the product itself. Another interesting point is a product's intended protective function. So if a product is designed to prevent harm but fails to do so, it can be considered defective. Consider a radar system that relies on AI algorithms to detect in real time the movements of vehicle occupants. If the product aims at preventing accidents, such as, for example, a child or an animal being left unattended in a car, but the radar fails to operate as intended, there's a high likelihood that the product would be deemed defective. So maybe to pause here, what that means is if we look at all of these changes regarding the notions of product and effectiveness, the scope of liability has simply grown. Problems that might not have counted as defects before could now trigger claims, and manufacturers need to review and adapt product testing to make sure they meet the safety criteria listed in Article 7 of the new PLD. Also, product records need to be looked at with greater attention in light of another groundbreaking change, which is brought by the new PLD in terms of disclosure requirements. So Sebastian, now over to you to start our deep dive on this topic.
Christelle, thank you so much. And let me also highlight two things. In the meantime, while we've started this, so many more people joined, so the attendance numbers go through the roof. So thank you so much. That beautifully ties into a second element. Let us share with you, we have a Q&A button in this session that you can hit. We said earlier, we're recording this. You're not being recorded, and you can anonymously, if you want, post questions into the Q&A section that then Christelle and I will see. We can either, during our presentation, directly jump on those questions, or we'll have a little Q&A afterwards. So don't be shy, feel free to use it. We know there is a lot we can cover here, which brings me to one of the topics we deliberately want to focus on. So our entire products law team in all the jurisdictions affected by the PLD is diving into so many aspects. And while doing this with our clients, this is one particular feature that we see interests basically all our clients from Europe, from the US, from Asia, because it's a sensitive one and it's about evidence disclosure obligations. So those of you familiar with liability cases or even other cases. It can be investigations, it can be a lot of different scenarios. You're well aware that some jurisdictions have certain evidence disclosure, or often called discovery rules. So far, under the PLD, there were only very limited scenarios in which there was an actual discovery obligation. There were certain burden of proof aspects, reverse burden of proof. Don't want to go into too much details here, but now with the new PLD, for the first time, we'll have an explicit and a quite aggressive evidence disclosure obligation explicitly in the law. And now, because it's a directive, expecting all 27 EU member states, including France, including Germany, you name it, to actually implement these rules into our national laws. I'm going to start with Article 9, which has two paragraphs, two main paragraphs at first, and then we dive deeper. Paragraph 9.1, and you see it on the screen. I'm going to read it together with you because I would say you got to see it to believe it. What happened in the EU right here, right now, is it says member states shall ensure, that's because it's a directive, it needs to be implemented, at the request of an injured person who is claiming compensation in proceedings before a national court for damage caused by a defective product, defined as the so-called claimant. We say claimant now, basically mean a plaintiff, and who has presented facts and evidence sufficient to support the plausibility of the claim for compensation, so meaning their alleged product liability claim. The defendant, those are typically our clients, the defendant is required to disclose relevant evidence that is at the defendant's disposal, subject to the conditions set out in this article. We're going to talk about these conditions set out in this article more in a second, but let's first digest this article. So what happens is we need a claimant, meaning a plaintiff, and we got to be before a national court. We're not talking about sort of out of court discovery, disclosure, and it's most likely also not some kind of a pre-trial thing. We're talking about before a national court. So we're in court. We've got a plaintiff, and this plaintiff typically, we don't know yet because it needs to be implemented in the member states, and we need to see how individual judges and courts are basically implementing it in their daily work. But there will be, that's how we understand, a request coming from this plaintiff saying, okay, I want evidence, and quote, I want all the evidence that is at the defendant's disposal. And that can be a lot to disclose. And then basically what the court needs to ask itself is, well, did this claimant make his or her alleged claim plausible enough? And now when we talk about specifically AI systems, and we're going to dive deeper in a second, of course, those systems are often complex. But just to take a random example, let's take an example of a product that has certain AI features and that is operating in some way autonomously. The moment a consumer, a person alleges and sues, becomes a plaintiff, that this product malfunctioned and thereby injured him or her, that might already be quite enough to make it plausible. Of course, there might be additional hurdles, but I'm saying a plausibility threshold is not the highest threshold in the world. So it can depend on the case, but judges might be inclined to grant such a request, which would then lead to the point said, well, then evidence at the defendant's disposal might need to be disclosed, but subject to the conditions in this article. We're going to talk about those in a second. There's a second paragraph. Oh, sorry, let's stay on this slide for a second. It's the flip side. It says member states shall also ensure at the request of the defendant, so typically our clients, that the presented facts and evidence sufficient to demonstrate the defendant's need for evidence for the proposed and countering the claim for compensation. So we need to say, dear judge, we hereby request evidence from the plaintiff that we need to properly defend this case. And then again, and that's interesting here now, because the threshold here is different, because then it's, again, what is available, of course, but there is no limitation that says subject to the conditions set out in this article. So that can also be, especially with AI, an important defense argument where a company might be able to ask a plaintiff to, for example, hand over the product for analysis, hand over the data on the product for analysis, because often, again, this webinar is specifically about AI. I understand from engineers, without having access to the product, the unit, the code on the unit, what the unit has maybe learned, processed, stored, data on the unit, it's often hard to say why the unit behaved the way it behaved. So that can also be an interesting defense argument. If a plaintiff is asking for information, so can a defendant. And typically that allows us to analyze certain things that we might not have been able to analyze before. So far, so bad. Let's jump to the next slide where we have these so-called conditions set out in the article. So if a company in the future is facing such a request for evidence disclosure, what is the lay of the land? What are the rules? Those are the paragraphs in Article 9 that outline these rules, and they can be specifically mind-blowing when it comes to AI. So paragraph 3 states, member states shall ensure that the disclosure of evidence, pursuant to Article 1 and 2, remember Article 1 is a plaintiff requesting information from us that is at our disposal, and in accordance with national law, whatever that means, that's a rabbit hole, because 27 member states can have different national law setting out certain national rules how this is going to happen, but here it comes, is limited to what is necessary and proportionate. So the plaintiffs are not getting everything when it comes to AI. They only get what's necessary and proportionate. Then paragraph 4 gives more guidance. It says, well, member states shall ensure that when determining whether the disclosure of evidence requested by a party is necessary and proportional, national courts consider the legitimate interest of all parties concerned, including third parties, in particular in relation to the protection of confidential information and trade secrets. That's now becoming particularly delicate when we talk about AI, which is typically highly confidential when it comes to the source code, when it comes to the software architecture, when it comes to basically how this AI is designed, how it works. So courts need to accept, it's in the law, that confidential information, trade secrets are protected. But the point is, when you read it, it's not saying they're not up for discussion. It says, well, when determining whether the disclosure of evidence requested by a party is necessary and proportionate, then the point is they need to consider that, the legitimate interest. So it doesn't mean trade secrets are off the table. It means it needs to be considered. Of course, the bigger the secret and the bigger the confidentiality, of course, the stronger the defense argument is. The next thing is it says all parties concerned. One might think it only means the parties of the lawsuit, but the law then says including third parties. So that could be, as far as we interpret it, anybody. It can also be a supplier. Maybe the party that is being sued, the defendant, is not identical with the entity or corporation or person who programmed the AI or who, quote unquote, owns the AI, owns the source code. So it's also about information that is being passed along in the supply chain that can and should also be protected. Paragraph 5 states something along those lines. Member states shall ensure that where a defendant is required to disclose information that is a trade secret or an alleged trade secret, national courts are empowered upon a duly reasoned request of a party or on their own initiative to take the specific measures necessary to prevent the confidentiality of that to preserve the confidentiality of the information. So the courts by themselves need to preserve the confidential information, especially when they're in the process of assessing it. Again, when we talk about AI and an AI product, I mean, one of the most sensitive things is, of course, the source code, the architecture, the back end. So one might want to be specifically careful and especially mindful, also educating a court how certain information must not be given out, must be protected. So again, this has a lot to do with tech in our view, and also how the logistics work. It's typically not just, okay, it's on a thumb drive, here you have it. There is more behind this. So these proceedings, they need to be developed, and by law, member states shall ensure it. So it's now also up to the member states and their courts to embed this into their respective systems, but also into their mindset. Last but not least, member states shall ensure that where a party is required to disclose evidence, national courts are empowered, so the courts themselves are empowered, upon a duly reasoned request of the counterpart, so plaintiff or defendant, or where the national court concerned deems it appropriate, so the court can do it by itself, and in accordance with national law. Again, that can mean a lot, talking about 27 member states, to require such evidence to be presented in an easily accessible and easily understandable manner if such presentation is deemed proportionate by the national court in terms of costs and effort for the required party. So it mentions costs, it mentions efforts, but the bottom line here for us is when we talk about highly complex and sensitive and trade secret protected AI, it can be quite a struggle, especially when a court says, look, I want this presented in an easily accessible and easily understandable manner. In all fairness, I'm a lawyer, I'm not an engineer, and I'm definitely not a software engineer. Much of these things are highly complex and I only understand certain parts of it. If a court now expects a party to present this evidence in an easily accessible and easily understandable manner, that can mean a lot, and that can pose or create a lot of challenges for a company. So again, we're closely monitoring it, but especially, again, our topic today is AI. When it comes to AI-driven products or the AI itself, that in our view is something that can mean a lot of things. I pause here for a second and I see a couple of questions here. Let me just pick one or two out to start with. So one of the main questions here, I like that one, is plaintiff lawyers. Are they preparing for it? Are they seeing it? Are they aiming for it? Will they exploit it, use it? That's how I understand this question. Our quick answer is most likely yes. I mean, we don't see these cases yet because at the moment, of course, the member states are implementing the PLD as we speak. Some have already presented drafts. The associations in those member states have already started to give guidance on these national drafts. But we, of course, see plaintiff lawyers to start advertising for this law, getting themselves into position. And that, of course, such an evidence disclosure obligation is something that most plaintiff lawyers will not miss. They're looking forward to it. And I'm a little bit careful to use this word, but I dare do it. I know we're recording it, but I see a high risk that they might even try to weaponize it. So it's one thing to aim for fair trial and fair proceedings, but the way this is drafted, and we've seen how plaintiff lawyers behaved in the past, we see a substantial risk in various of these jurisdictions, together with our European teams, sister teams in all these markets, that plaintiff lawyers are aiming to weaponize it, to use it to their advantage. Just to give one example, maybe to even wrestle companies into agreeing to settlements just to avoid the risk of being forced to disclose certain information or to discuss certain confidential protected information with a court, in front of a court, which can create damages, losses that go beyond what is on the table with the product liability claim. So yes, we're seeing those plaintiff lawyers. A very good question. Thank you for raising it. And this is something that we're preparing for and that we also encourage our clients to prepare for accordingly. Christelle, I talked a lot. I paused for a second. What are your thoughts? How are you seeing it in France in particular?
Well, in France, we had already seen some attempts for this type of evidence required before the proceedings actually start. There is a legal ground available for that already under French law, but of course, the new PLD, which will really push that forward and make it a lot more attractive for plaintiffs. And of course, the challenge I see, as you were flagging, is that it feels like we're asking a lot from companies in this text, and something like a catch-22 situation, because you cannot really provide information about very complex products in an easily and accessible and easily understandable manner. And so the question will be how to get the court satisfied with what defendants will be able to provide when it comes to AI-driven products. And not even touching on the secrecy and the very touchy nature of a lot of that information in terms of competition, etc. So it's gonna be clearly one of the challenge, and this is why I said, I think earlier, that it's probably the most groundbreaking provision in the new PLD.
Then I would say if we jump to the next slide, we can give you another one we would like to focus on. Again, there is a lot to cover, but especially with a focus on AI, we believe that burden of proof should be front and center of what we are preparing for, and in light of the question we've already seen, what we believe the other side, the plaintiffs, are aiming for. So let's start with a quick comparison, left and right. You see it on the slide, the old PLD, still in effect, and the new PLD. So with the old PLD, burden of proof is, generally speaking, for the damage, the allegedly defective product, and the causal relationship, that's on the injured person, so the claimant or the plaintiff. That basic principle does not change under the new PLD. So they've slightly changed the wording if you look to the right, but the general idea is a claimant, remember it's been defined in the law now, is required to prove the defectiveness of the product, the damage suffered, and the causal link between the defectiveness and that damage. That's pretty straightforward. That has not changed. However, if we jump to the next slide, something significantly has changed. And for those who looked into the lawmaking process and the recitals and everything that happened between the sort of old PLD that's in effect for 3 decades and this new upcoming PLD, is that allegedly the lawmakers said, look, there is some kind of a dissymmetry, an information dissymmetry. Plaintiffs are struggling. So you remember we've got an evidence disclosure obligation now. And the other one is they were saying, look, the plaintiffs are struggling with their burden of proof. So the law now, we've discussed this, gives them evidence disclosure right. And on top of it, it also modifies the burden of proof. So a question, and by the way, I also saw it in our Q&A section already. Thanks for anticipating that. We get a lot from our clients. We specifically get it from US clients because they use the disclosure discovery a lot in the US. We've been asked, well, Sebastian, this evidence disclosure obligation, if we don't satisfy it because we disagree, we're saying we're not giving our source code, we're not giving our software architecture, we're not giving this, we're not doing it. What happens? How is a court going to sanction us? And the best answer I can give you at this point is it's not going to be a fine. It's going to be that very Article 10, Paragraph 2 that we're looking at right now that says, well, look, the defectiveness of the product shall be presumed, so legally presumed, where any of the following conditions are met. And then letter A says the defendant fails to disclose relevant evidence pursuant to Article 9.1. So if a court orders us to disclose something, we say, no, that's a trade secret. And the court tells us, well, I see it differently. I think that the plaintiff's interests outweigh your interest in protecting that. It should be on the table. I want to know, I want to see. And I want it in an easily understandable way. We say no. then one of my best answers at the moment is, ask me more definitively once we've seen it in court. But one of the best answers I can give you right now is, well, Article 10, Paragraph 2A. Then the court will have to presume that the product is defective. So if we fail our evidence disclosure obligations, we might also fail to point towards a plaintiff and say the burden of proof is on you. You need to show that our product is defective. It's your full burden of proof. We might lose that one. So for that reason, it can be very important not to fail to disclose relevant evidence, which again, by law, would then happen basically in reversing the burden of proof, making for the court an easy step to say, well, then I presume the defectiveness. The second thing when a court presumes the defectiveness is when the claimant demonstrates that the product does not comply with mandatory product safety requirements laid down in union law or national law that are intended to protect against the risk of the damage suffered by the injured person. So you remember when we introduced ourselves, both Christelle and I, we said, look, we're part of our global team and we're both doing product liability and product safety. Guess what? It gets more interconnected every day. So basically, now we're explicitly pointing towards product safety requirements and now talking about AI. You know, there are a lot of rules out there these days, and we're not gonna float this webinar by pointing into all the other areas of law we're covering on a daily basis. But the bottom line here is that we have an explicit interconnection between product safety law and product liability law. And for example, if you're in exchange with a market surveillance authority on a safety topic, you've recalled a product, etc., the AI is under fire. There are technical standards that might be referenced in certain mandatory legal requirements that might play an even more important role now. And if a plaintiff is able to point in that direction, again, it might completely switch and flip the burden of proof. The product is presumed defective and it ends up in a sort of back against the wall situation here. C, if a claimant demonstrates that the damage was caused, and here it comes, by an obvious malfunction of the product during reasonably foreseeable use or under ordinary circumstances. That's a very tricky one. We need to diligently work and see how we might be able to stop plaintiffs from exploiting this. But here's a very simple case study that one of our clients asked us. We're talking about AI. Let's just for a second assume we talk about a vehicle and we talk about a self-driving car. And if this self-driving car is in self-driving mode and it ends up in an accident, I'm not saying, I'm asking, is that an obvious malfunction of the product? Is any accident that a self-driving car finds itself in automatically an obvious malfunction, saying, well, the car shouldn't crash, right? There shouldn't be an accident. Is that it? Or is it more complex than that? And one must need to say, well, just the mere fact that it's an accident does not mean it malfunctioned. So this is something that plaintiffs might try to exploit by their statements, maybe witness statements, maybe simply by pointing towards what's obvious in an alleged scenario. So when does an AI behave state of the art? When is it maybe not the AI's fault and everything's fine? And when is it what the law calls an obvious malfunction? Especially with AI that has certain failure rates, that has certain limitations, those can be tricky ones. And then, of course, the causal link between the defectiveness of the product and the damage shall be presumed where it has been established that the product is defective and the damage caused is of a kind typically consistent with the defect in question. So, I mean, let's take my traffic accident example. Again, I'm not stating, I'm asking, but if you're in a traffic accident and you had no back pain when you entered the car, and after the accident, when you leave the car, you have back pain, is that what the law means? And so, well, that's typically consistent with an accident and those kind of damages. And if we presume the vehicle is defective, then we can now also presume that there is a causal link between that accident and the damage. And it makes life for plaintiff lawyers easier. So that is again something we need to prepare for. The burden of proof is still up on the plaintiff, but their life became easier. And it even gets worse. But I pause here for a second because we got a couple of questions already before we jump further. One is any argument that norms, harmonized standards are not mandatory. So again, we got to see how this unfolds in front of courts. We talk about Article 10, paragraph 2b here, where it says, well, mandatory product safety requirements. Our position typically is that a mere technical standard that is not explicitly listed in the law is nothing more but a mere technical standard, and therefore it typically reflects the state of the art at the time it was created. But that's the difference between the law, a law like, I'm just picking one randomly. If you build a machine, well, you've got the machinery directive now, and you'll soon want to have the machinery regulation. And that's mandatory binding law. However, there are countless technical standards. ISO, EN, German DIN standards, can be foreign standards, US SAE standards, you name it, global standards. Those are generally not mandatory product safety requirements in our view. But of course, if I were a plaintiff lawyer, they might try to make the argument. But that's exactly what we've been preaching for decades, that standards can have a certain relevance. And if there is a standard violation alleged, that is something that companies should closely monitor and deal with. I think at this point, Christelle, can I quickly pass the torch over to you? And then we've got a lot of questions here. I digest those simultaneously, but do you have something to add regarding those questions that you've already seen, or something from your perception, from the French perception, your work in this area in the last 2 decades?
Sure, thanks, Sebastian. Maybe coming back on the question as to whether not satisfying the plaintiffs and the court would result in a finding against the defendant in terms of liability. I think the main change is that before, the court had some leeway in interpreting what the silence or lack of disclosure of the defendant meant. But now there is clearly a duty on the court to reach a finding of liability, as you were clearly explaining. So this is where we see a major change here. And I think there was another question regarding whether there could be injunctions to compel disclosure by the defendants, and the clear answer on that one is yes. The way we would expect things to unfold in, the most likely scenarios is, as Sebastian was explaining, first the claimant sends a request to the defendant to get evidence. The defendant responds based on their understanding of the request. And of course, as defense counsel, you do what you need to do, but nothing more as usual. And then probably claimant will come back and ask for more, saying it doesn't meet the requirements of the new PLD. Then back and forth could develop. And then, if the parties do not reach a mutual understanding of how to apply the new obligation to disclose evidence in the specific circumstances of this case, well, the court will be referred to the question, and the court will indeed decide whether the defendant met its obligation or not. And in the latter situation, it would likely enter into an injunction to disclose evidence. And what I would say, because this is not the first area where we see mandatory disclosure of evidence, what will really be key is looking at the wording of the request for evidence and also order of evidence to disclose evidence from any court, because in this matter, really the devil lies in the detail, I would say.
I
Sebastian. Do you want to continue?
Definitely, and I couldn't agree more. I'm wondering, we've got one beautiful question here, and as a German, we've got this thing like one step forward, two steps back. I think now would be a great time to answer that question, but to do so, would it be possible if we jump back to slide 8, which should be Article 9, paragraph 3 and 6? Yes, spot on. And so that question is built around number 6, where we discussed, well, if a court is concerned and deems it appropriate, when it asks for evidence presented in an easily accessible and easily understandable manner, what happens when this is violated? And that, again, to this question, it has got two elements in my view. One is, yes, exactly, that might be enough for a court, and it's a little bit of a jumping thing here, to say, well, yeah, that might violate that obligation if it's not presentable in easily understandable way. So Article 10, paragraph 2a, that says if the defendant fails to disclose relevant evidence pursuant to Article 9.1, then the defectiveness is presumed. But, smart question, it says Article 9.1. And now we're talking about Article 9.6, where the court says, well, I want it easily understandable. Can we say, well, look, we presented the evidence. The fact that you don't understand it, dear court, and you want it in an easily understandable manner and easily accessible, that's, I mean no disrespect, I'm just stretching the argument now. That's your problem, dear court, not ours. You can't presume a defect just because you don't understand our evidence. That is an interesting way of looking at it. It's a very smart question. In my view, it's a little bit tricky, though, because when we go back another slide, I said Germans like one step forward, two steps back, one slide back, where we talk about what's our obligation. Article 9.1 says, subject to the conditions set out in this article. So basically, Article 9.1 is referring down into the conditions. So I'm not stating, again, I'm asking, I'm a little bit careful now to jump to conclusions too quick, but a plaintiff lawyer, of course, might try to argue and say, well, if you violate Article 9.1, your product is presumed defective, and Article 9.1 refers to the conditions set out in this article. So if the court says it doesn't understand the evidence, then the court basically needs to presume it's defective because it doesn't understand what you've presented. That's a tricky one. And then there is a follow-up question that is very beautifully linked to this. If we again go one slide forward, thank you, you're the best, amazing, to 9.6. The question is, again, thanks for it, it's very smart. Does that for the first time mean an evidence disclosure does not just mean putting evidence on the table that is at our disposal, or might this even mean create new evidence that is easily accessible and easily understandable? Just an example. Again, not stating, just thinking. Example, what about a translation? If a court says, well, it's great, you're an AI tech company, but everything you do is in English. I'm a German court. I want this translated. Otherwise, I don't understand it. Is that then something that's covered? Or is that something where one might have to say, well, then we're creating new evidence because now for the first time we're creating a language version. Is that a thing? Or is this just a mere translation? Or when a court says, oh my God, this is tens of thousands of pages of engineering gibberish that I don't understand. I want a beautiful executive summary summarizing what I'm reading right here because I want it, like, sort of give it to me in English. Like, I want it understandable, easily understandable manner, no engineering gibberish. Is that what's meant by that? Which would then again maybe force a company to create new evidence in the first place because that summary never existed. But the court is saying, I don't understand these 10,000 pages. This is your internal stuff. I need this presented in a way I understand. It's a very good question. We don't have the answer yet. Of course, we will advocate and say this is an evidence disclosure obligation. So we cannot be expected to create something new out of thin air just because it pleases the court, or it, even worse, pleases a plaintiff saying, well, I want this smoking gun from you, and I want it in a way that basically has a headline saying I'm the smoking gun, and I want it easily understandable. I'm quite reluctant to would go that far. To me, it's an evidence disclosure obligation, nothing more. An evidence disclosure obligation should never, in my humble opinion, lead to the creation of new evidence that wasn't there in the first place, just because a court or a plaintiff takes the position we don't understand the existing evidence, we want it presented in an easily understandable way. That's my humble opinion here, and that's exactly where we believe we need to draw the line. So thanks for those two questions. And then I warned you, I'm a German. So now we jump again, one step forward to back. We go to the burden of proof, but 233. Excellent. So there's more. It gets worse before it gets better. So we've already talked about some of the burden of proof rules that have been implemented in the law. So here is a new one again. What about that one? A national court shall presume the defectiveness of the product or the causal link between the defectiveness and the damage, or both, where, despite the disclosure of evidence in accordance with Article 9 and taking into account all the relevant circumstances of the case, and here it comes. That's a real terrible one for AI in my view. The claimant, meaning the plaintiff, faces excessive difficulties, in particular due to technical or scientific complexity in improving the defectiveness of the product or the causal link between its defectiveness and the damage, or both. And the claimant demonstrate that it is likely that the product is defective or that there is a causal link, and so on and so on. So here's a tricky one. When we talk about AI, and again, I'm not a software engineer, we're defending companies for many years. If the burden of proof is upon a plaintiff and they just allege things, not particularly legal what I'm saying now, it's often a strategy to just say, look, this is completely unsubstantiated. These cases are complex, blah, blah, blah. Now, for the first time, there is this quite, let's call it interesting, burden of proof presumption for defectiveness in the law that says, well, if the claimant faces excessive difficulties, in particular due to technical or scientific complexity, ask yourself, I'm not stating, I'm just asking, when we talk about AI and AI systems and AI products, are those often products that are linked to a certain technical or scientific complexity? When people are saying, well, millions of lines of codes, and this is black box, it's a learning AI, it's been trained, nobody really knows why it does what it does. And now a plaintiff finds him or herself in front of a court and says, well, if this is all so complex, how am I supposed to prove the defectiveness? That is difficult. And now it's a question, well, where does excessive difficulty start? Difficulty itself doesn't seem to be the problem. We're talking about excessive difficulty, and then we talk about technical or scientific complexity. Again, this is going to be something we will closely monitor and we'll strongly support our clients with. But that is something we see where plaintiff lawyers are preparing for, because it might make their life, allegedly, significantly easier by just saying, look, Your Honor, this is excessively difficult for my client. This is all cutting edge technology. This is technically complex. Let's reverse the burden of proof. Let's presume it's defective and let the defendant show that their AI was free from defects. And that then again switches everything. That was, I believe, one of the last core messages we want to send in this time. We're still perfectly beautiful in the time. We have still some questions left. I would start, Christelle, if that's fine. Over to you if you still want to cover some of our Q&A questions. I mean, we can give people some minutes back. We don't want to go over time, but I think there's at least time for one or two last questions.
Sure. I see one question which we did not touch upon, which is, well, this is a European directive, so it needs to be implemented in each member state. Where do we stand there? So I suggest I start with France and pass over to you, Sebastian, to say a couple of words on Germany. But for France, the situation is still calm. There is 1 year to transpose the directive yet, and we don't have a draft yet. So we'll see when lawmakers in France can turn their attention to that topic, but we don't foresee an anticipated implementation here on this text. So what about Germany, Sebastian? I've heard there is a draft, right?
Right. So in Germany, we have a draft PLD now that's coming from the ministry, and we already have one round of opinions being shared from the associations here in Germany. It's been highly discussed, but the quick message is, in summary, it's a little bit more common, but in summary, the German lawmakers are copy pasting a lot. So they just take the German wording of the German version of the German PLD and copy paste it into the German draft PLD to implement it, which of course is good news in terms of consistency. That's good. We're not freestyling here in Germany. That shows leadership and consistency. On the other hand, I mean, looking at the PLD, it leaves a lot of unanswered questions when it specifically references to national laws. So many of these gaps are unclosed and are open. This might be a good thing for our clients, but again, of course, it poses challenges. But that's the situation we're seeing. We continue to closely monitor it. And if there is anything you need from any of us in our global products law team, from all our jurisdictions, we've got colleagues, by the way, also from our sister team here in Munich, from our sister teams in Italy, and of course, we've got our French team also on this call. If anybody needs anything, feel free to reach out to our team anytime. All of us are closely monitoring this. Then we can give you 1 minute back. Thank you all very, very much for joining this webinar, and have a beautiful day. Bye all.
Thank you. Bye.